So Professor Gillers, thanks for joining us today.
Thank you for inviting me.
So for those who haven't taken one of your ethics courses, what can they expect?
Well, a lively discussion, a range of subjects, both intellectually interesting and practical, across a 2 to 3 hour period with audience participation and real-life examples.
So how do you choose the examples in your courses?
I have about 60 different topics that I've accumulated over the years. I look them over. I look at what the City Bar or other bar associations have said in recent ethics opinions. I look at court cases that may have changed the law in some way, New York State courts, the federal courts. I look at law review articles, and I talk to a lot of lawyers and hear what they consider to be the issues that confront them. And all of that eventually bubbles up into a syllabus from month to month.
And do you prepare your courses in such a way that people can take them more than once a year?
Oh, right. I think no two courses are identical. Some issues repeat because there are changes in the doctrine. Conflicts, for example, subsumes a dozen separate legal ethics questions. And those dozen evolve over time as ethics opinions and court cases come down. So a person could take the class every time it's offered in a year and never see the same lesson twice.
So can you give us some examples of recent cases or items that have happened in the news that are fodder for your course?
Well, the ones that I have done recently include social media, which is a big issue now. What ethical issues are raised by using social media, YouTube or Twitter or blogging, the issue of potential clients. What happens when you talk to someone who may become a client but then does not? What are the conflict ramifications of that for you and for your colleagues? Recently, the New York Court of Appeals decided a case involving compensating lay witnesses. How much can you pay a lay witness who will testify in your client's behalf? That's an important case. It was a unanimous decision. It was not clear how it might come out, and I think lawyers who litigate need to know about that. So those are some of the issues I've covered recently.
Since you brought up social media, I'd like to digress for a moment and ask you about that. It seems like lawyers are warned and advised against getting too involved in social media. I mean, from an ethics standpoint, is it like is it a dangerous terrain for lawyers, or do you recommend that they not get involved at all, or is there a way for them to get involved safely?
Yeah, it's not dangerous. There's some risk. Care will avoid the risk. I think lawyers must consider using social media. It's not for everybody, but it is a way of networking. It is a way of learning. It is a way of making your availability to prospective future clients known. So I think for a lot of lawyers, especially lawyers younger than 40, say, the use of social media to build their career is desirable, advisable. Now, there are dangers, and as there is in any kind of public announcement or public pronouncement, an advertisement, for example, there are dangers, but they can be circumvented, and the challenge is to understand where the limits are.
Okay. Can you give us sort of a forecast of what's coming up in some of your courses in terms of issues?
Sure. Well, legal fees and the hourly rate bill, this has been in the news, certainly the legal news, for a long time. There's a lot of client dissatisfaction with hourly rates. On the other hand, sometimes they are essential. And so the next CLE will delve into the hourly rate and how it can appropriately be used and where it can be abused, what to avoid, what to do. Advance consents is a current issue. To what extent can a lawyer and the client agree that certain prospective conflicts will not disable the lawyer or the lawyer's firm from representing a new client. Conflicts that cannot be fully anticipated, that's why they're advance consents, but that can nonetheless be solicited from an informed client and enable the lawyer to accept a matter that he or she might not otherwise be willing to accept or able to accept.
Okay. Let me ask you an unusual question. Do you feel that the legal profession and/or society at large is becoming more or less ethical?
Well, I can't speak about society at large. I think that compared with the legal profession when I entered it, there's much greater emphasis on ethical rules. I have a case book. It's now in its 9th edition. The first edition was kind of brief. There wasn't all that much to put into it. There was something, but not a whole lot. Today, the material is enormous, and I have to decide what to cut and how. So I think that our awareness of so-called ethical rules has grown enormously. And they're not just rules of ethics or rules of professional conduct. Rules governing lawyers come from many places. They come from statutes, and they come from cases. And even the ethical rules are not really ethics in the traditional sense. They're rules that can get you into a lot of trouble if you violate them. So really, they're a kind of law. They're not ethics pure and simple.
Right. So you've been teaching ethics courses at the CLE Center at the City Bar for a long time. What is it about the City Bar that attracts you to teaching here?
Well, doing a CLE at the City Bar is different from other CLEs I do at corporate law departments or law firms. And the reason is that the audience is much more varied. You can have matrimonial lawyers and prosecutors and criminal defense lawyers and business lawyers and negotiators and litigators and in-house lawyers and outside lawyers and government lawyers. And so that's a challenge when I think about the syllabus, because not every topic will be immediately pertinent to the practice of every lawyer in the room. It's simply impossible to do that. On the other hand, I want enough of the topics to be germane to what a lawyer in the room will confront on a weekly or monthly basis, so he or she feels that it produced some practical utility. Now, even if a topic is not immediately useful to a particular lawyer, because of his or her own practice, it may be important to the practices of other lawyers with whom that lawyer works. Or it may be important to the client because of the conduct of the opposing lawyer, right? So it's your job not only to stay ethical, but to protect your client from the misconduct of other lawyers. And so you need to know the rules governing them. So, for example, if we talk about criminal defense lawyer conflicts of interest, a prosecutor has to know that because it may be necessary to move for disqualification if there is a conflict that threatens the effective assistance of counsel. Or in-house counsel tend to have very few conflict problems personally, but they hire lawyers and they have to protect their client against the conflicts of the lawyers they hire from private law firms.
I see.
So I try to think of a melange of issues that will be at least intellectually interesting to everybody, and many of which will be germane to the practices of lawyers in the room.
Great. Okay. I think that brings us to the end. Is there anything you'd like to add?
No, I think that there is one thing, and that is because the room is composed of lawyers from many walks of life, many kinds of practice, one of the fun things for me is to get a conversation going. And I try to encourage people to participate. And almost never do we finish the syllabus. because as we move through the topics, people have questions that branch off into a related area. And my view is that if you're having a good conversation, you can sacrifice a topic for the depth of the discussion. And then the next time I do it, I can revive the topic I didn't cover that time.
Great. And I should say here that anyone interested in taking Professor Gillers' ethics courses here at the City Bar Center for CLE should check our website. That's www.nycbar.org/CLE. Professor Gillers, thanks for joining us.
Thank you.